third and final day. Reference by the Attorney General for normalising of devolution issues under paragraph 34 of Schedule 10 to the Northern Ireland Act 199.
Yes, Ms. Buttercup.
Good morning. We've had a discussion amongst Council about timing. I'm going to be as quick as I possibly can this morning. I'm then going to hand over to Ms Kelly, who will also be as quick as she possibly can. We think that if we're lucky, we may be able to claw back some of the overrun that's happened so far. But otherwise, Ms Sutton, on behalf of the official solicitor, has agreed with Mr McLennan, hopefully, that her full allowance of 55 minutes will still be possible for her. So yesterday, I set out on behalf of the charities the position that valid consent is, for relevant purposes, the same as informed consent, and the approach to consent and capacity under the domestic frameworks. If the court isn't persuaded by that, the further submission on behalf of the charities is that the proposed test of whether someone is displaying something, and I quote, beyond mere acquiescence, that's the hearing bundle at 271 from the Attorney General, is a vague, unworkable, uncertain test which is impossible to implement in a way that doesn't remove safeguards from people who obviously need them. The court has in the draft code a little more detail about what might count as being sufficient for this incapacitous valid consent. An actively expressed positive wish about the arrangements. That's page 276 of the key documents bundle. And an example is given of someone who regularly says that they like where they live or who appears keen to return home and doesn't display evidence of resistance or objection. And we say that all of that raises more questions than it answers. What counts as a sufficiently positive wish? For what do you have to display a positive attitude? Is it all the arrangements or most of them? Is it over a period of time, or is a snapshot assessment adequate? If it's a period of time, what period is that? And one of the particular points that the charities make in this connection is that by reason of the mental impairments and disabilities that people in this group have, there will be people who display what is referred to as challenging behaviour, who are prescribed sedating medication as a result, either on an ongoing basis or an as-required basis. There will be people whose care plans authorise the use of physical holding to restrain them. One can look at those interventions in two ways. One is to say, this person's disability has manifested itself in a way that calls for these interventions. And so if they are agitated and throw something across the room and are physically restrained to stop them injuring somebody, that is just that's just the response to a manifestation of their disability. That's not resistance to or objection to their care arrangements. That's just how things are for that person. And it's not at all clear how any of that complexity could factor in to what's proposed. One answer would just be to say, well, anyone who's in receipt of a care plan that has chemical sedation or physical restraint in it falls within Article 5. But that's not what's being suggested in relation to Limb B. In relation to Limb B, somehow the person's attitude to those restrictions has got to be understood. And it's entirely possible to have, and the examples from the charities give actual real-life examples of this, people who display challenging behaviour and are subject to those kinds of interventions, but aren't expressing dissatisfaction with their overall living arrangements.
But what's your position? Are you saying that if anyone is sedated, then that should count as non-consent?
Well, our primary submission is that if you're going to put this forward as a test, the onus is on you to explain how it works.
Right, but I was asking for your position.
Yes, so
because we're now interpreting the Article 5 jurisprudence.
Yes.
What do you say?
So we certainly say that if going down this path, the only safe route is to take the generous interpretation.
So does that equate to, if anyone's been sedated, they're treated as being objecting to their confinement?
Or is it wider?
It's
that lack of capacity equals lack of consent?
So that's our primary submission, is that
Yes.
you just don't get into this territory.
Yes.
But when we're in this territory, whereas we know that you lack capacity, but you are giving what is seen to be valid incapacitous consent, what is it that divides you from the other people in that category? And what's said is, well, it's a positive attitude to the arrangements. What I'm saying is that where those arrangements include things such as sedating medication or physical restraint, the only safe route is to take those sorts of measures as being ones that are incompatible with having a positive attitude, because otherwise you get into this territory of saying, well, you seem to be happy to live here and you like to come home every day back from the day centre. Okay, 3 times a week you're physically restrained by your carers, but overall you're happy here, and so you're now in this category of people that the Attorney General says are giving this incapacitous valid consent, and the charities say that would be wrong.
Right. I didn't understand why you said that we don't get into this territory on your primary submission, that it's all to do with lack of capacity. Because you can have capacitous adults who
Yes.
are subjected to sedation from time to time, can't you?
Yes, absolutely. This is but we're only talking here about this sort of, and this is where the sort of air of unreality about all of this comes in. If someone is capable of giving valid consent, consent carries with it the idea that if you give or withhold your consent, there will be a different outcome. If you withdraw your consent, people will stop doing the things that you had said you didn't want them to do to you. But we're not in that territory here. The territory we're in here is that you can give this valid consent, but the minute you withdraw it, possibly, or the next week, you're then treated as not having given the valid consent, and the whole time the arrangements that apply to you are exactly the same. You're just dipping in and out of the safeguards.
Okay.
But if they're being sedated,
Yes.
would there have to have been some other process by which that kind of treatment is approved by somebody?
No, so not for people in the community. So the process for example, for Meg, who was in receipt of risperidone, which is an antipsychotic medication, the process would have been an assessment of whether she had capacity to decide to consent to taking the medication that her psychiatrist wanted to prescribe to her, or her GP. And if she didn't have capacity, a best interest decision about whether to prescribe it. And that
Who
would be
would take that?
That would be the medical professional, would be the decision maker pursuant to the Medical Capacity Act Code of Practice.
And that best interest decision would take account of her wishes and feelings.
It would.
Notwithstanding her lack of capacity.
Of course, absolutely. Best interest decisions always take account of wishes and feelings. Of course, by definition, in a case such as that, the medication is being advised by a medical professional because they see it as necessary to treat symptoms of agitation and so on.
But it seemed to be, I think your primary case is that you don't get into this because actually the consent test is a test about weighing information, retaining information, being able to take that kind of decision.
Yes.
But one might say, well, the Strasbourg court seems to think that there is the possibility of consent even for someone who doesn't have mental capacity.
Yes.
So they must be talking about some different kind of consent, which is
Yes.
then when we get into this, how happy do they seem to be, how much do
Yes.
they like going back to the home, which is nothing to do with weighing and retaining information and taking decisions.
Yes.
Right. So then if we get into that territory, then you're saying, first of all, you have to be very careful given all the evidence we have about are they really happy or are they just saying that?
Yes.
And then there's the question is, are they happy because they're taking medication which is making them appear to be happy?
Yes, absolutely. And then are they, someone could, as in our examples, be happy with their care arrangements overall, but those care arrangements could still involve highly restrictive interventions, which at the point where someone's being physically restrained, it's difficult to say that they're happy with their care arrangements because someone's holding them down and stopping them doing the thing they want to do.
We're asking whether they're happy being deprived of their liberty.
Yes. Well, and so that's the question. What is it that they then have to be happy about? Because the care arrangements for people are going to obviously include all sorts of different measures. And that's why I say there are all these questions that are posed and not answered. You know, what is it within those care arrangements that you have to be happy about? Is it all the time or some of the time? If what's being done to you is in response to a perceived need arising from your disability, does it matter whether you're happy about that or not, or is that just a response, an appropriate response to keep you safe and keep other people safe? We then get into the difficulty of fluctuating wishes and how you judge the point at which someone has slipped back to the other side of the line and they're no longer expressing a positive attitude. There are the problems set out in the charity's evidence of pressure, coercion and duress, none of which actually requires bad faith even, because of the nature of the mental impairments that we're concerned with.
Okay, can I just ask?
Yes.
How conceptually do you square your proposals in relation to the subjective element, which seems to be full consent to
yes.
what has been done, with the scheme, the intellectual scheme put forward by Strasbourg? Because Strasbourg is addressing issues of consent at the stage of whether there is a deprivation at all. If there is a deprivation and you fully consent to it, well, then you would have waived whatever rights you might otherwise have had.
Yes. So I think
and one sort of difficulty I have with what you're saying is that you seem to collapse the mental element
yes.
Into what would be a full waiver requirement under the application of the European Convention. There doesn't seem to be a gap between those two. In which case, why do you say Strasbourg has emphasised that at the stage of deciding whether something is a deprivation in the first place,
yes.
it's the same test as it would be if you were waiving your rights if a deprivation was established?
Yes. So the way I would conceptualise it is as follows. So in respect of Lim A, the question of confinement is there, do we even get off the ground in terms of is there an objective deprivation of liberty?
Right.
Is that one of the questions that's asked every time following Ghazadi is the person free to leave? Asking whether someone is free to leave will always you'll be helped in answering that question by looking at whether they are in fact objecting, and by looking at whether if they did object, someone would stop them and bring them back.
Okay.
And so that, to that extent, that question of the person's objection comes into the question of whether they're free to leave as part of the objective element under Lim A. But what we know from HL is that that is not a necessary condition in the context of someone who doesn't have capacity to make these decisions. And so while understandably you see it drawn on in every single case, because all the cases that come to Strasbourg are people who are objecting, that's how they get hold of a lawyer and bring their case. Apart from HL's case, of course, where it was his parents who were able to do that on his behalf. While you see them say, well, the objection counts in the first question about the objective deprivation of liberty,
right.
That in my submission doesn't give you the answer as to any of the other things that we're talking about in relation to the reference.
Okay. My question was directed more to how you account for Lim B.
Yes.
Because you seem to, as I understand your submission, Lim B seems to have the same content as would a question about waiver of rights under the Convention.
So in relation to Lim B, what we say is that this question of valid consent, that the substance of the consent that Strasbourg is interested in is the same as the substance of the consent that people are interested in under the domestic frameworks in terms of capacity.
Right.
And that Strasbourg then goes on to ask a further question, which is even if it is validly given in a substantive way, they're still willing to accept it, which was the N in Romania case.
Right. I'm not sure that if I may say so, that's quite answering my question. So I'm not looking now at the interface between the Strasbourg framework and our domestic framework.
Yes.
I'm looking at the way in which the Strasbourg framework operates. Lim B is the subjective condition. on your, as I understand it, on your submissions in relation to Limb B, you need capacity in the full sense that you get under domestic law, which is as full a sense as actually I can imagine capacity is.
Yes.
If that's the case, the test under Limb B seems to be precisely the same as the test for actual waiver of rights under the convention. I mean, you all sorts of convention rights, you can waive your right
Yes.
to rely on them if you consent in a capacitous way to being treated in.
Yes. Well, I think that's right.
And that's, so my question is really,
Yes.
why do you interpret the Strasbourg case law as, in effect, treating condition B as the same as the test for full waiver of rights, but yet introduce it at the level of definition of whether there's a breach of rights in the first place?
So, I mean, we say that you can see this from HL. What Strasbourg says is that people who don't have capacity to make the decision, they're not in a position to waive their rights, and so we don't go there. So the fact that we end up in that situation, we say, does follow from the case law, and the attempting to use the cases about people who are able to express these views and weigh up the things doesn't help you deal with that.
All right, thank you.
So I've dealt with these questions about what on earth any of this means, how you find who these hypothetical people are, how you judge it, and so on. It's said that there are adequate safeguards that the concerns the charities raise don't need to be worried about. The court's already heard a little bit about the framework in England and Wales, where there is a deprivation of liberty, which entitles people to all sorts of safeguards that they are not entitled to otherwise, and which are different to safeguards under community care legislation. There are just a couple more points to flag up about that, which we have addressed in our annex. So the first is in relation to IMCAs. IMCAs are appointed under the general terms of the Mental Capacity Act in England and Wales for one-off decisions in specific circumstances. In contrast, in the DOLS system under Schedule A1, a relevant person's representative must be appointed for every person. And part of that person's, the test for appointing that person is, will they be able to keep in touch, keep in contact with the person? It's an ongoing role, not someone who comes in, supports someone to make a decision and then goes away again. That's paragraph 140 of the schedule, which is page 779 in the hearing bundle.
779?
779.
Thank you.
And those community care provisions, of course, don't apply to mental health hospitals, so they wouldn't, none of those measures would have helped Mr. HL. What you also have in Schedule A1 is a positive obligation in the statute on the care provider to actually request a review of the deprivation of liberty authorisation if things on the ground change. And so there are paragraphs 102 to 107 of the schedule, which is hearing bundle 768, sets out the circumstances in which people can request a review, but also in which the care provider, the managing authority, needs to trigger a review. And there aren't any equivalent statutory provisions outside the deprivation of liberty scheme that actually mandates that sort of process of having to review things if things change. The annual framework for Care Act assessments and so on is a snapshot intervention at a point in time. We've included in our submissions reference to the report of the House of Lords Adult Social Care Committee, A Gloriously Ordinary Life, which starts at page 7480, which explains how that system works or fails to work in real life, and which notes that a few years ago now, there were 2.5 million people aged over 50 with an unmet need.
And do we have that in the bundle?
Yes, yes, and that reference is page 7491. 7491.
Thank you.
We've also included the Care Quality Commission's report, Out of Sight, Who Cares?, which concludes that that this is a system where people with complex needs fall through the gaps, and they conclude we cannot be confident that their human rights are upheld, let alone be confident that they are supported to live fulfilling lives. And that is page 7339.
It said against you that the reason why this is so problematic is that the resources are being stretched
Yes.
too thinly because there are so many people brought into the system by Cheshire West. And I think Mr. McLennan said if you really focused on the people who needed it, then the care that they receive might be better.
Yes, and obviously there's an inherent tension in, I think, some of the submissions the court's already heard, because I think Ms Clement said, well, there are 400,000 people in a backlog, and if we didn't have all of them in the backlog, then people would get better attention, while simultaneously saying that the current safeguards are good enough anyway, even without that system. But that takes me on really to the substantive issues about the objective limb, which I'm going to deal with as briefly as I possibly can, because I know that this is a subject that the official solicitor will be addressing. The charities understand the wish to reduce the administrative burden, and also the wish not to end up with what seem like counterintuitive conclusions about people being deprived of their liberty. We've seen in the cases of Ferreira and Briggs that the lower courts have been able to do that. They've been able to carve out categories of people from and distinguish them from the approach taken in Cheshire West. And they cover people in intensive care or in hospital who are receiving treatment for physical conditions, essentially. What the charities disagree with is that you can extend the reasoning in those cases to social care, because what you run into saying if you do that is that if restrictive care is needed because of someone's disability, then it isn't a confinement. And if one steps back a bit and thinks, well, what is it the court's being asked to do? If we think back to P in the Cheshire West case, in fact, someone where everyone in the Supreme Court agreed was deprived of his liberty. He was in a supported living placement. There was physical restraint from time to time. I think what's being said is that if Cheshire West is overturned, then even he wouldn't be counted as deprived of his liberty. And so...
I thought, but he's physically restrained.
He is from time to time, yes.
So that would be quite a strong factor against what you've just said.
Well, one would hope so, but that's not... it's not clear from the way in which these carve-outs are being put forward that that's the case. So what's said on behalf of the Secretary of State is essentially that if someone is so severely disabled that they can't form their own view about wanting to leave or physically get up and walk out of the door, then they shouldn't fall within this category. I think that's what's being said. It's hard to know exactly where these lines are being drawn. We have the example right at the far end of the person that Professor Eldergill identifies who is so unwell with dementia that they've stopped even being able to swallow. Well, with the greatest respect to Professor Eldergill, that person does not have long to live and is very clearly at the end of their life. And what these cases and what the court's being invited to do is to extend that well beyond that individual into the person in the next room in the care home who has advanced dementia but is being over-medicated with antipsychotics, or the person in the room beyond that who hasn't yet been medicated on antipsychotics but nevertheless goes to the front door of the care home every day and asks to be let out.
Well, what is your position in relation to someone in a catatonic state because of dementia?
So I think firstly we would slightly struggle with the suggestion that there are people in a catatonic state because of dementia.
So it's just a category that doesn't exist, is that what you're saying?
There are certainly people with dementia who are not able and don't express views or opinions about things and who aren't physically able to get up and move around. We accept that. What we struggle with is drawing a line from someone in intensive care or hospital receiving treatment for a physical illness.
Yeah, no, I understand that you don't like that, drawing that line, but my question was, what do you say about...
Well, on our analysis, the people with advanced dementia would still be caught within the system, because we're not seeking to say to the court that Ferreira and Briggs are wrong. We think that line can be drawn. but we don't think it can be extended in the way that's suggested without you giving
those
a reason
people are not
that
in the
applies more
Ferreira.
broadly.
Sorry, those people you would say are not in Ferreira bricks.
So does that mean they are being deprived of liberty, even if they can't form a will of their own to leave the
Yes.
circumstances in which they are? Right.
Yes,
Okay.
absolutely. And we've given examples in our case studies of people who you could possibly describe as not being able to form a will to leave, but who are nevertheless subject to care packages that we would say ought to fall on this side of the line. And we recognise, as I think everyone would have to, that drawing this line is not straightforward. And that, as was said in Cheshire West, one eventually ends up having to say something like, do we err on the side of caution or not? Because drawing the hard line is really difficult. And the charities draw it in a different place. The charities draw it on that side of caution to say that there will be some people with dementia who don't need the safeguards, who aren't being given antipsychotic medication, who are just lying in the bed in the care home, and who have carers who are bringing them food and drink and are bothering to wash them. But while we accept that there are those people who will have the safeguards but never need to exercise them, we don't think the right answer is to take them away from everyone who is in that visible category, because it includes all the other people.
How the need to protect
Yes.
people as a matter of policy? Where I'm struggling is the idea that if someone is not able to form the intention to leave or is not physically able to leave,
Yes.
that they come within Article 5, because Article 5 is about protecting people's autonomy and giving them the physical liberty not to be restrained. If people cannot exercise that physical liberty, are you within Article 5 at all?
Well, and
or do we have to, as a society, find another way of protecting these people?
The charities really, I think, on that would just say that there are people with profound learning disabilities who have very limited ability to form views, to proactively decide to do things. They find it very difficult to accept that the nature of someone's disability in that way could be used to say that they don't have the same protections and safeguards as people who are slightly less disabled.
Well, I can see that as a matter of policy, but
Yes.
my point is that within Article 5?
Well, we say that the way the courts have dealt with it so far is the right way of dealing with it. And so you can take out the Ferreira and the Briggs type cases, you can take out the people who are receiving the treatment for physical illnesses and so on. But we just say once you start on that line of saying, well, this person is so disabled that they fall outside, you are firstly going to find it difficult to come up with a principled reason as to why you've drawn the line in a particular place, and also going to find it very difficult to actually identify where that line is in practice in a way that anyone will be able to understand and implement.
Yeah.
Thank
you.
And I think the last point on that would just be to say, we also say that courts should be very cautious about trying to do any of that in a situation where they don't have any real life examples of that sort before them.
Yeah, I'm not sure where that takes us, because we've got to resolve the reference. So
well, exactly. So
we've been given evidence, quite a lot of evidence,
Yes.
about real life examples.
Yes, so the evidence from the charities is dealing with the reference, and we certainly say the court can deal with the reference. It's the separate argument raised by the Secretary of State through the intervention in relation to the objective limb that I'm dealing with at the moment, and that I say the court needs to be very careful about. Which is the perfect place for me to conclude my submissions on behalf of the charities and to pass over to Ms Kelly, who is going to very briefly deal with the reasons we say that the court shouldn't look at that issue that the Secretary of State has raised.
Yeah.
Yes, Ms Kelly.
My lords and my ladies, this is not an appropriate case in which to apply the 1966 practice statement. The question of when to apply the practice statement was recently considered in the Dalton case, and the charities submit that the reasoning across several of the judgment is applicable in the present case. My Lord Reid summarized his reasons for declining to apply the practice statement at paragraph 5, and if I could take the court to page 3952 of the main hearing bundle. My Lord Reed noted that as a general rule, the court will be very circumspect before accepting an invitation to invoke the practice statement, because it is important not to undermine the role of precedent and the role of certainty which it promotes. My Lord Reed noted three primary reasons for not applying it in the Dalton case. The first being that it was unnecessary to decide the point in order to decide the present case, that the earlier decisions had been correctly decided and, to say the least, were not clearly wrong, and that departing from the earlier decisions would have a damaging impact on legal certainty in circumstances where maintaining a clear and consistent approach is particularly important. If I could take the court now to 3964 of the main hearing bundle. My Lord Reed's judgment in Dalton continued at paragraphs 46 and 47, again noting that where it was unnecessary to decide the point, it was not appropriate to apply the practice statement, and noting a number of very important policy reasons at 47 as to why the court is so circumspect to apply the practice statement. I would note particularly that the court will not overrule a previous decision simply because the justices would decide the case differently today. The principle is vitally important to the operation and reputation of a court which does not sit en banc and whose composition consequently varies from one case to another. In such circumstances, the principle is essential to counter the risks that the outcome of cases might otherwise depend, or at least might appear to depend, on who happened to be sitting. It was also essential to enable the consistent application of the law and its coherent development to take place. Noting the case of Hudson, if a tenable view taken by a majority in the first appeal could be overruled by a majority preferring another tenable view in a second appeal, then the original tenable view could be restored by a majority preferring it in a third appeal. The finality of decisions would be utterly lost. In the interest of time, I won't take the court to the joint judgments of Lord Hodge, my Lord Hodge, my Lord Sales, and my Lady Rose, who set out their reasons at paragraphs 168 to 171 of the judgment for reference at 3998, even though they felt a previous Supreme Court decision which had been taken had been in error. They noted in particular that the previous judgment, even though they felt it was wrong, had created a high degree of legal certainty, and that it was not necessary to determine the issues at hand in the Dalton case. The charities say that it is inappropriate to apply the practice statement for 6 reasons. The first reason is that applying the practice statement in relation to Cheshire West is not necessary to determine this reference. The reference is about a policy which offers a new interpretation of the subjective limb of test for deprivations of liberty. The question in the reference is framed as whether the code of practice could be revised to provide that, in the context of the delivery of care and treatment, individuals aged 16 and over with impaired decision-making may be understood to be consenting to confinement through the expression of wishes and feelings. Cheshire West was an appeal strictly on the basis of an objective test for the deprivation of liberty, which is how this court also characterized Cheshire West in the case of Reed D. in 2019. The Northern Ireland policy also explicitly adopts the Cheshire West test for an objective deprivation of liberty, and there is no challenge to the objective test, Cheshire West test, in the reference. Again, in the interest of time, I won't take the court to it, but this is at 278 of the hearing bundle. The policy very clearly adopts the acid test in Cheshire West as the 278 in the hearing in the main hearing bundle.
278
explicitly adopts the acid test in Cheshire West and is not challenging it. I would also note in the Attorney General's submissions on Monday, it was accepted that they had not proposed to change the acid test, and that was not the reference that had been brought before the court. For Dalton, it would be inappropriate to apply the practice statement where it is unnecessary to determine the reference, and in my submission, it is. The second reason why I would submit that it is not appropriate to apply the practice statement is contrary to what is said by the Secretary of State for Health and Social Care. There is no lack of clarity about what a person must consent to on the subjective limb of the deprivation of liberty test. It is their residence and care arrangements, including any restrictive elements of those arrangements. The subjective test is concerned as to whether the person has given valid consent to those arrangements, not whether the arrangements are an objective deprivation of liberty or merely restrictions upon liberty. The third reason why I would say it's not appropriate to apply the practice statement is that there are no new Strasbourg authorities that meaningfully change the European case law on Article 5, the Article 5 objective test since Cheshire West on the objective limb. It was not seriously argued otherwise by either the Attorney General or Secretary of State, who both accepted that the case law had not meaningfully changed and that this was a case where they were looking to apply the practice statement rather than to say that Cheshire West was out of date. The fourth reason why I would say it is inappropriate to apply the practice statement is that there is a strong interest in preserving stability and clarity of existing precedent in this case. Whether or not this court would have reached the same conclusion on Cheshire West has created stability and clarity on the legal definition of an object of deprivation of liberty, where there had previously been high levels of confusion among professionals who were tasked with overseeing people who may or may not be deprived of their liberty. Mind, who is one of the charity interveners in this case, was also an intervener in Cheshire West. One of the key purposes of Mind's interventions in Cheshire West was to bring awareness to the widespread operational difficulties which had arisen around the deprivation of liberty safeguards framework at that time, and Mind provided an overview in its evidence in the 2013 hearing of the concerns which had been identified by stakeholders and monitoring bodies. If I could take the court to 158 and 159 of the main hearing bundle, particularly noting paragraphs 15 to 20 in Mind's evidence. This is a summary of Mind's evidence as it was before the Cheshire West Court and helps to explain what the legal framework looked like at that time to people who, on the ground, were charged with administering it. If I could take the court to paragraph 18 on page 159, noting in particular people who actually had to make decisions as to whether real people were deprived of their liberty. Advocates and professionals on the ground struggled to keep up with the evolving case law and to apply it in practice. In response to Mind's call for evidence, one professional said, "I have to return to previous training materials, search the internet for up-to-date case law, and speak with colleagues each time a deprivation of liberty is raised as an issue in terms of the Mental Capacity Act." Another said, "The system is just confusing, and the definition of deprivation of liberty changes each time a case goes to court, with judges contradicting each other." Again, in the interest of time, I won't bring the court to it, but I would note that this was very much corroborated by other reports at the time. The House of Commons Health Committee prepared a report, again, contemporaneously around the time Cheshire West was decided, which is in the bundle at 6675, which emphasized the high levels of confusion on the ground. The CQC prepared a report which said essentially the same thing, which is in the bundle at 6601. Per Dalton, stability is extremely important in precedent and a key reason not to apply the practice statement in this case. Where the definition of a deprivation of liberty tracks Article 5, even if, as the Secretary of State now proposes, a code of practice was brought into place, professionals on the ground would still have to know what the case law said in order to be able to correctly apply whether or not they needed to apply for a deprivation of liberty safeguards in any particular case. It is entirely unrealistic to think that care home managers, social workers, hospital administrators should have to keep abreast of Strasbourg and domestic case law in order to determine whether the person in front of them is or is not deprived of their liberty. What they need is a clear and workable standard to apply on the ground, which Cheshire West has provided. Setting aside Cheshire West would certainly lead to high levels of first instance judgments as any new standard or lack of standard was worked out on the ground, which would again lead to high levels of confusion and people not having the protection that they need. The fifth reason I would say that the practice statement should not be applied is that the law has not, as was suggested, ossified. The Secretary of State has set out in their written case the matters of Ferreira, Briggs, and SM, which I won't take the court to, as it's been taken to some of these matters before, but it is key to note that all of these decisions have distinguished Cheshire West on the basis of particular facts. We would also note that in all of these cases, the courts have directly applied Strasbourg case law. They have not seen Cheshire West as the beginning and the end of the inquiry, and that is not at all uncommon in cases where there is a real question as to whether or not a person is or is not deprived of their liberty. To these, we would also add the case of Reed D., which was heard by the Supreme Court in 2019, which we'd also note that the Department of Education and the Secretary of State for Justice intervened specifically on the question of when a child was deprived of their liberty for the purposes of Article 5, and in which that case the government did not argue that Cheshire West was wrongly decided. Again, I won't take the court to it, but if the bundle reference for that is 3376, the case of Reed D. As a more recent example of the evolution of case law on this, I would note Manchester City Council and P, which again, I won't take the court to in the interest of time, but 3816, which made findings about restrictions which were non-physical restrictions, but still very acutely felt by the person in question, and finding that these were not a deprivation of liberty because they did not have that physical element. I would also note the suggestion by the Secretary of State that it's very difficult for them to get involved in first instance cases or in cases other than this reference to raise the arguments that they have raised here are not entirely accurate. I would note that the Department of Education intervened in the case of Jay and Bath and Northeast Somerset Council, which again I won't take the court to, but the reference for that is 3925, which involved a profoundly disabled boy who was found not to be deprived of his liberty at the first instance on the basis that the judge found that there was subjective consent. However, he was described as well settled in his placement, well cared for, and in many ways almost a paradigmatic example of what the government is now arguing is a person who should not be considered to be deprived of their liberty. While the government did intervene in that case, they did not run the arguments that they're running here. And I would submit that it is not accurate to say that this is the only forum in which those could be raised. That case was heard at the Court of Appeal. The government would have been entirely free to run that on the basis of actual facts.
What was the name of that case?
Jay and Bath and Northeast Somerset Council at 3925. My sixth and final reason that I would submit that it is wrong to apply the practice statement in this case is it has been repeatedly raised that there are administrative problems in authorizing deprivations of liberty following Cheshire West. The Cheshire West test for an objective deprivation of liberty in no way obligates the government to run the particular scheme that it currently runs. And the Cheshire West decision itself explicitly stated at paragraph 57 that a less elaborate scheme could be put in place and that the processes could be streamlined and simplified. This simply hasn't happened because it has been repeatedly delayed. I know that the liberty protection safeguards have been in statute in the Mental Capacity Act since 2019. They were consulted on in 2022, and only Friday the government announced that they would consult on them again, but they have effectively been delayed for years on end for no obvious reason. It is entirely within the gift of the government to design a less onerous system if they feel that the current system is too onerous and too difficult to run. I would note briefly, as an example of this, there are two different systems for authorizing Article 5 detentions within England and Wales alone, under the Mental Health Act and the Mental Capacity Act. The Mental Health Act system is much more streamlined than the Mental Capacity Act system and has generally been considered to be valid from an Article 5 perspective. The Mental Health Act forms are generally only a few pages long. For an example, authorizing a renewal of a long-term detained patient of the Mental Health Act is a 5-page form which is typically filled out by hand within a very short period of time. The Northern Irish system shows how many efficiencies can be made by removing the court authorization process for deprivations of liberty and moving those into an administrative basis. My overarching submission is that it is not a good reason to apply the practice statement due to administrative difficulties which are entirely within the hands of the government to fix. This is a matter that Parliament could attend to if it wished to, and in fact has attended to. It simply hasn't brought these matters forward by actually implementing the liberty protection safeguards.
Is there somewhere in the papers which describes the liberty protection safeguards and what they would be if they were?
The liberty protection safeguards are in the bundle.
Yeah, I don't need. I just wonder if there's somewhere we could go to in due course to.
Thank you. My lady, I'm told that my learned friend, Ms. Sutton, will be speaking more about what's implemented by the liberty protection safeguards. I can note as an overview in terms of the streamlined that they would put people onto 3-year authorizations instead of 1-year authorizations. So that would immediately greatly reduce the number of authorizations that would happen on any given basis. They change the range of professionals who can complete the forms, and they provide for an administrative form of detention for people in the community. So this would take out the court authorization process into a much less administratively burdensome process. Finally, and while obviously I've not addressed this in any detail, it would be our submission that Cheshire West could on no account be said to be clearly wrong, and is certainly a tenable decision. On that note, I would hand to Ms. Sutton, who I understand will be considering this further.
Thank you, Ms. Kelly. Yes, Ms. Sutton.
My lords, my ladies, I appear on behalf of the official solicitor to the Senior Courts of England and Wales with Mr. Haddon. We are very grateful to the court for granting us permission to intervene. Our written submissions are in the supplementary bundle at page 4 to 28, and the witness statement of the official solicitor is in, again, the supplementary bundle at pages 29 to 84. There are 5 areas that we seek to assist you with. Firstly, the distinctive role of the official solicitor in this reference, emphasising some of the evidence that she has placed before this court to hopefully bring the abstract to life. Secondly, we will address you on Limb B, so that's the specific question raised in this reference. The official solicitor agrees with the substance of the submissions made by the charities. I will briefly seek to supplement them. The third issue relates to Limb A. We will address you as to why Cheshire West is not clearly wrong, as argued by the government, such that you should depart from it. Fourthly, very briefly, I will deal with the likely implications of persons no longer falling within Article 5 if Cheshire West is departed from, in response to some of the submissions of the government regarding safeguards. And finally, fifthly, as to why you should not invoke the 1966 practice direction in the specific context of the issues now before you. So turning to the first issue, my lords and ladies, and the role of the official solicitor. The official solicitor is an independent statutory office holder appointed under Section 90 of the Senior Courts Act, and one of her primary functions is to act as litigation friend in civil, family, and court of protection proceedings, and it's the latter in terms of her role that we'll be dealing with today. And the whole purpose of the official solicitor is to protect the interests of those who lack the ability to protect themselves, either because of minority or because a lack of mental capacity. Now, there's no individual person or persons at the heart of this case, so the official solicitor is not here today as litigation friend, so she is participating in this reference to assist the court insofar as she is able on the issues raised. So how is the official solicitor to assist you? Well, firstly, my lords and ladies, she is the only person who has direct experience of very frequently being a party in the Court of Protection in England and Wales. So she can assist you in terms of how the issue of deprivation of liberty is being considered by the courts in England and Wales on a day-to-day basis. And secondly, she is the only party who, on a very frequent basis again, in her role as litigation friend, has to ensure that P's wishes and feelings, insofar as they are ascertainable, are maintained in terms of this statutory requirement insofar as Section 4.6 of the Mental Capacity Act is concerned. Very briefly, in terms of what's changed on the ground, you'll see from the official solicitor's witness statement that there has been a significant increase in the number of cases where she is invited to act as litigation friend. It's within the bundle, the supplementary bundle at page 34, paragraph 20, and that provides you with some facts and figures in terms of the number of welfare referrals that she has received since March 2014, when Cheshire West was decided. She also deals, my lords and ladies, at page 34, paragraph 21, that of those referrals that she is now receiving, which is increasing gradually on a month-by-month basis, that many of those, and it's likely most of those, involve a consideration of whether P is deprived of their liberty. There's a table that I hope is helpful. It's on page 46, paragraph 67, which you're able to look at in due course, but that gives you some flavour in relation to the amount of referrals going into the Court of Protection, the amount of applications concerning, there are 3 different frameworks, the REEX procedure, which is a streamlined procedure, a Section 16 procedure, and a Section 21A procedure. So 3 types of processes where she's involved. In terms of the statistics that you've been provided with, and we've done our very best, what you don't see and what we're not able to tell you is what exactly those cases were about, but what the official solicitor is able to say is that in her experience, during the course of proceedings in the Court of Protection, she is responsible for ensuring that there is a forensic analysis of the circumstances of the case. So on the individual's behalf, as the litigation friend, she is able to make sure that scrutiny is brought to bear in those proceedings. And what often happens, as we will see from some of the cases, is that there are changes made to care planning arrangements to make the changes less restrictive, to allow people to have a greater degree of freedom to pursue their interests. And in some cases, following that forensic analysis, there is actually no deprivation of liberty. So it's an essential safeguard that she is part of that process to make sure that planning arrangements and the implementation of highly restrictive regimes is kept as least restrictive as possible. Moving on from some preliminary points, the witness statement at page 52 to 65 in the supplementary bundle starts at paragraph 80 with providing the court with 13 real-life examples, suitably anonymised, to contextualise the legal arguments and bring them to life in this reference. And what we say is that those case studies are broadly representative of the range and the variety of cases where the official solicitor is appointed to act as litigation friend. And the types of cases are those like Cheshire West, where you are looking at the living arrangements for a mentally incapacitated person and whether they amount to a deprivation of liberty. And I would ask my lords and ladies, when considering this matter, to look at those 13 examples in full. But for my purposes, if I can emphasise 3 orally, very briefly, and the choice of them is because of the different types of placements, the aspects of them being supported living, one's own home, and then an adapted bungalow. So if we can look together at case study 1, the name of the case is Francis, so I'm in the supplementary bundle, page 52, paragraph 82. And this first case study is a person in their 60s with severe learning disabilities in a living arrangement. It's a supported property. And Francis, in this case, was reportedly able to indicate that he was happy, pointing to a smiling face on an easy-read document. So, on a perfunctory basis, everything looked happy and well. When this matter got to the Court of Protection, and this was objectively scrutinised within the court arena, it was determined that he was not in fact settled, his placement was at risk of breakdown, and the proportionality and the necessity of the restrictions were challenged on his behalf by the official solicitor. But looking at what my lords and ladies are dealing with...
So how did it get before the Court of Protection then?
So that was a situation where the Schedule A1 process would not apply. So there would not be a standard authorisation because it's not a care home or hospital setting. So in this type of arrangement, those who were responsible for the package of care, either the local authority or an NHS body, would bring the matter to the Court of Protection and say, these circumstances are likely to constitute a deprivation of their liberty. We need this to be authorised in accordance with section 16(2)(a).
So this was the first time in which there was a deprivation authorisation for him?
It doesn't specifically say that.
But it could have been.
It absolutely could have been, that it's brought to the court's attention, my lady, because the care regime in place on the ground is such that when you implement the care plan, there are carers going in, and we go to the continuous supervision and control, not free to leave aspect. So those responsible for the care would make the application to the Court of Protection, and they would ask the court to authorise those restrictions, and the authorisation under the Mental Capacity Act, pursuant to sections 16(2)(a) and 4(a)(3), are made by the court. And then that can be up to a year, and it's subject to review. But in this circumstance, my lady, bringing it back to the proposal of the Attorney-General, due to the reported happiness of Francis, there would be no deprivation of liberty. So he would not have received the necessary protections in terms of an application being made to the Court of Protection, the involvement of the official solicitor as litigation friend, and specialist lawyers acting on his behalf. Because the contentment on the Attorney-General's case would take him outside the ambit of the Article 5 arena that we're looking at. So that's one very real-life example and something that's very commonplace on the ground. The second case... I'm sorry, my lord.
Yes, paragraph 86, do we know why the placement was at risk of breakdown?
The facts haven't been provided. They're anonymised and they haven't gone into the level of detail that one would have in the actual case. But placement breakdown details are for all sorts of reasons, my lord. But the point is, if there is a placement breakdown issue, then that needs to be properly looked at, because that person would lack the capacity to make decisions regarding their residence. So that enters the process of best interests. So again, you would need to make sure that there was an appropriate framework to make sure that that move of placement was properly exercised on their behalf.
Right. Because presumably placements can break down for reasons other than, for instance, that Francis was unhappy with where he was.
I've just been told that if one looks at the preceding paragraph, there's an issue in relation to behavioural issues.
Right, okay.
Paragraph 85, my lord.
Yes, thank you.
The second case study is Arthur. That's at page 54, paragraph 87. This is a young autistic person who lives in a specially adapted bungalow.
Just going back to Francis.
Yes.
The previous paragraph, 85.
Yes.
He had attacked staff resulting in injuries. He didn't understand why he was not allowed out and became frustrated as a result. No longer happy.
Yes.
And, so he would now, that wouldn't meet the subjective element under Limb B.
No. And it also shows the variability in relation to the expression of contentment, and that's a problem on the Attorney General's case.
Under the Attorney General's case, he would be detained.
Yes.
Yeah, under Article 5.
Yes.
So the same process would apply as now?
So the same result would be achieved under the Attorney General's case as the one you're advocating for.
Well, on that one example, I think it shows the variability of what we're looking at, because that person, in terms of the contentment, it's not static, and I think that's one of the problems in understanding how it will work in practice.
But I mean, that's going to be the case under any regime, that situations may fluctuate.
Yeah. Yes, but when you've got people as vulnerable as this, my lord, it's an issue of making sure that whatever the safeguards are appropriately analysed.
Right, okay.
The second case study is Arthur at page 54, paragraph 87. So this is a particular case that you were referred to yesterday by my learned friend, Miss Butler-Coles. So this is the person who is living in a domestic setting, an adapted bungalow, but in a perspex box. So this was a case where he was being kept within the perspex box in the house and being fed through a hatch. He was reported to be content, but it's clearly a highly restrictive regime. And this was a case where during the course of proceedings, so the matter gets to the Court of Protection, again for the authorisation of the deprivation of liberty in the community. During the course of those proceedings, there was expert evidence obtained dealing with the use of restraint to ensure that the restrictions were the least restrictive possible. And it made sure that in addition to the expert evidence, the court was scrutinising the care plan, again looking at how often it needed to be reviewed. But due to Arthur's contentment, irrespective of that highly restrictive regime, he would not be deprived of his liberty in accordance with the Attorney General's proposal, because that would not go to court if he is saying, I am content, irrespective of the highly unusual circumstances that the adapted bungalow give rise to. So without that court application and the involvement of the official solicitor and the specialist lawyers, notwithstanding that extreme environment, nobody would be looking out and checking that situation was appropriate. So that's an example, and that's a real-life example that has gone through the Court of Protection. The final case study, just to deal with orally, my lords and ladies, is case study 8. That's George. That's in the supplementary bundle on page 59, paragraph 108. And this is a home that's owned by his parents. So at first blush, you look at this, it's a domestic setting. He's a male in his 30s, moderate learning disabilities, autistic, has anxiety and some sensory difficulties, and he requires 24-hour care on a one-to-one basis. He has behaviours that are said to challenge. He's injured himself. Medication is given to him covertly in a drink. But importantly, for the purpose of the reference, he is content with the arrangements of his care. This is a situation where, due to his health needs, his care is funded by the local Integrated Care Board under NHS, CHC or continuing healthcare funding. And that's not unusual in terms of NHS packages of care in a home environment. But what is interesting in relation to this particular example is that George was in agreement as to some aspects of his care, so he was content in relation to the address where he lived, the residence aspect, but he was not in agreement in relation to the restrictions in the care plan. So there's a separation out in relation to what somebody is actually consenting to. And that is problematic in relation to the reference before, my lords and ladies, because at the moment it seems to a blanket position that the person is happy by reason of the expression of their wishes. But in this case, happy with residence, but this person was subject to CCTV monitoring. So there was somebody watching when this person was walking around their own property. And it was imperative that when this got to the Court of Protection, that monitoring, that highly restrictive aspect of the plan, was looked at carefully. And it was, during the process of the Court of Protection and the involvement of a litigation friend on his behalf and the input of the Court of Protection judge, that that restriction was removed to make that a less restrictive home environment. So the point I'm making, my lords and ladies, is it's not binary in terms of an agreement. Somebody can agree to some things and not all. But based on the stated contentment, George would not be deprived of his liberty on the proposals by the Attorney General. He would not be in receipt of the necessary protections for the independent review. So just to give you a flavour of the day-to-day type of cases that are coming before the Court of Protection up and down the land. And the conclusion of all of these examples is set out in paragraph 137. It's in the supplemental bundle on page 65 to 66. And what happens at paragraph 137 touches on a point raised by my learned friend for the charities to say, well, how does this all work in practice? What challenges are there going to be if the court is going to determine that incapacitated persons who are content with their confinement are not deprived of their liberty? And there are 7 points raised at page 65, paragraph 137, and it shows the complexities of the test that you're being asked to look at. So if you could deal with the 7 points in terms of a consideration in due course, I obviously won't take them through now, but the point about wishes and feelings fluctuating, being happy with parts of the care arrangement, and also agreeing to something in a complete vacuum. And that's important in my respectful submission. There are some persons in the community who have no understanding of any possible alternative. So they're simply agreeing to their regime in a vacuum. And there's also the point touched upon by my learned friend in terms of the use of sedative medication, there can be examples of covert medication. How does that impact on the ability to provide valid consent by the expression of wishes and feelings on the case put before you by the Attorney General? So those points draw all together the concerns that the official solicitor has.
Can I just ask you about George?
Yes.
And the proposed guidance at page 276. I mean, surely on the guidance at paragraph 2.12, George would not be consenting, because you made your point, sometimes people are happy with aspects of their care, but not other aspects.
Yes.
But 2.12 seems to indicate that you need positive wishes and feelings about the arrangements in place, all the arrangements. So George was unhappy with significant parts of the arrangement, so why would that not count as objecting in terms of this guidance?
But how would that, you can't compartmentalise George. He either fits into the system or doesn't fit into the system.
Well, it's more, you can't compartmentalise the arrangements in place, so he has to be happy with everything. Otherwise, if he's expressing significant objections to parts of the arrangements in place. I'm just looking at the draft view of paragraph 2.12, wouldn't that be caught under 2.12 as not counting as consent to his care?
I'm not sure, my Lord, because the detail that we've got currently in the code is very brief, and the contentment of George on this particular case in terms of the CCTV monitoring, I find it difficult to separate out somebody whose care plan needs to be looked at holistically.
Yes, I see. Thank you.
In terms of the official solicitor's specific experience of deprivation of liberty within a home environment, and that is something I understand has troubled my lords and ladies, I think it's important to emphasise, and again from the official solicitor's experience, this is commonplace in terms of supported living, adapted bungalows, own homes, and there is no Strasbourg jurisprudence to say that these types of environments, so the domestic setting, are precluded from falling with Article 5, and the Convention is a living instrument. And what I would ask my lords and ladies to consider is what Lady Hale said in Cheshire West. It's paragraph 56. The page reference is 2953, and I'll read out the important point from our perspective. It's that to set the cart before the horse is to decide that because a person lacks capacity and the best possible arrangements have been made, that they are not in need of those safeguards. Because in the end, it's all about the constraints that matter. And without protection in one's own home, it may normalise restrictive practices for a group of people who would have immense difficulty at asserting their rights and challenging inappropriate restrictions. And I would ask my lords and ladies, when deliberating, to look at page 1414 in the supplementary bundle, and this is a debate in relation to the Mental Capacity Amendment Bill in the House of Lords. It was a debate on the 21st of November 2018, and these issues of concern in familial circumstances was raised by Baroness Meacher, the crossbencher, who said that there are circumstances where abusive relatives may be depriving a family member of their liberty in an inappropriate, disproportionate, and even cruel way, and where access to a court is needed. And the point to be made is that just because restraints are deployed outside a hospital setting does not make it less restrictive or undeserving of independent scrutiny. The official solicitor also has experience of persons living with dementia in one's own home, and that has been raised, understandably, on a number of occasions. The point being that he, seemingly content, has no real understanding or awareness of their surroundings apart from perhaps periods of lucidity. But one goes back to the point that the person with dementia had a care plan that meant that their daily regime was controlled by others. And that control is important because they should not be disadvantaged from falling outside Article 5 and the independent review and the scrutiny of the care plan. And I would invite the court to look at what Lord Kerr said in Cheshire West. It's at page 2958, paragraph 76, where he says that liberty means the state or condition of being free from external constraint. And we agree. If I may, I'd like to address the point head-on raised by my Lord Reid, on Monday, I think it was, that people with significant cognitive impairments do not have liberty to lose. And I would invite the court to be extremely cautious before reaching that conclusion, having regard to the universality of rights. But perhaps more importantly, that requires a type of medical approach that P has no subjective experience of the world at all. And that's an extremely difficult conclusion to reach, but for unconscious or minimally conscious state. So the cases of Ferreira and the case of Briggs. And I say that because there is otherwise a spectrum of disability where there is no bright line. And it's impossible, we say, within the context of a reference and without specific facts, to try and seek a demarcation beyond the Ferreira and the Briggs analysis. And I should say, for clarity, that the official solicitor agrees with the decision of Ferreira and accepts that it is distinguishable from Cheshire West, and equally agrees with the decision of Briggs and accepts it's distinguishable from Cheshire West. So where does that take the court? Well, if P is unconscious or is in a minimally conscious state in hospital, and although they have a pre-existing mental disorder, that was before the onset of the physical disorder, and the pre-existing mental disorder has no impact on the care and treatment provided in hospital, then those cases we accept do not fall within Article 5. But we say that's the extent of any carve-out that can be undertaken in the context of this reference without any specific facts. You've also been raised the analysis of the person with advanced dementia, close to dying at home. The position of the official solicitor is that that would have to be decided on specific facts, and it would need to be a case properly considered and determined at first instance. It's just not appropriate, we say, to speculate on what those concrete facts would be for this hypothetical person and then try and reach a conclusion as to whether there was a deprivation of liberty. And I can't see that the Secretary of State has cited any reported cases post-Ferreira which demonstrates that persons in receipt of social care would fall outside Cheshire West. So, in short, the development of the case law, my lords and ladies, we say should be at first instance level with a clear factual matrix. If I can deal very briefly with the question raised by the Attorney General, so this is the second issue, I support, on behalf of the official solicitor, the submissions raised by Ms Butler-Cole in her analysis regarding Limb B. Just two additional matters. There was some confusion, it seemed, in relation to the issue of what was actually determined in Cheshire West. And if my lords and ladies want to look at the references in due course from the Court of Appeal, the first is page 2852. It's paragraph 18, and this is the judgment of Lord Justice Wilson, and paragraph 17 at 2851, where it makes it very clear that the issue of valid consent was not something that was going to be in issue. And similarly, in the Cheshire West and Cheshire Council and P case, Lord Justice Mumby says at page 2869, and it's paragraph 17, there's a reference that Mr. Justice Baker recorded it as being common ground, and that the second and third conditions were satisfied. And it said specifically that the subjective element is satisfied because P lacks the capacity to give their consent.
Not satisfied.
Everybody was satisfied that the subjective element was satisfied
Oh,
because
yes, sorry.
he
An
lacked,
absence of consent. Yeah.
he lacked the capacity to give his consent. So when it went to the Supreme Court, everybody was proceeding on the basis that that specific limb needed no further clarity. And the reason that I seek to clarify that is that now that limb B has been formally raised by the Attorney General, then you're able to clarify that valid consent to confinement, we say, can be dealt with by application of the Mental Capacity Act for the reasons articulated by Miss Butler-Cole, but it's not obvious to the official solicitor that you are in practice statement territory regarding limb B, because it doesn't appear that you need to overturn something that was not actually determined when one looks at what the issues were before Cheshire West in the Supreme Court.
And looking at both the references in both these cases, it seems that it was common ground that the limb B element was satisfied on the basis that, well, I'm looking at the P case, P lacks the capacity to give his consent, so that seems to have been on the basis of the domestic concept of capacity, is that right?
Yes, it was all dealt with by reason, as I understand it, to the Mental Capacity Act. And what would ordinarily be dealt with on a day-to-day basis is whether P lacks capacity to make decisions about their residence and care arrangements, and that would include the confinement aspect because you would be looking at the restrictions of the care. So that's the way it's dealt with on a day-to-day basis.
Yes, thank you.
The only other point to raise, just for clarity, and I'll be very brief, you were taken to a case post-Cheshire West by Miss Butler-Cole, Stankoff and Bulgaria, and it was in the bundle at 5207. You were taken to paragraph 90, and that was being utilised to show the fact that there is a close link between what the current position in Strasbourg is and the domestic situation, and you were taken to the fact that there needs to be credible evidence suggesting that the capacity to consent and to understand the consequences of that act have been established in a fair and appropriate procedure. All of the necessary information is provided, etc., and that's also applicable to a social care environment. If I could just ask the court, when deliberating, to look at that alongside what happens in England and Wales when you look at section 3.4 of the Mental Capacity Act. That statutory provision is at page 713 of the bundle, and it's just to show that the statutory wording is very similar. So section 3.4 of the Mental Capacity Act provides that the information relevant to a decision includes information about the reasonably foreseeable consequences of deciding one way or another or failing to make the decision of consenting to the arrangement. So the brief point I make is that the statutory language in section 3.4 of the Mental Capacity Act is closely aligned and we would say consistent with Stankoff. Turning to the third issue, the objective component. So the written submissions are dealt with very briefly by the official solicitor because of the way that this reference was provided, and these were intervener points as opposed to the question that was asked in the reference. So the written submissions are set out in the supplementary bundle at 26 to 27. It's paragraph 59 and 64 altogether. We support what was said by Ms Kelly, that the Secretary of State has not had an opportunity before to make the arguments that are now being made. But be that as it may, what we say in our submissions is that it's been difficult to try and deal with very abstract issues when one looks at the complexity of individual cases. And Strasbourg obviously doesn't deal with things in a vacuum. It's very fact-specific. So our oral submissions to you today in terms of limb A are that Cheshire West did not take a wrong turn when analysing how to approach limb A. We say that the court was correct to conclude that the Strasbourg decisions indicated that the features of continuous supervision and control and lack of freedom were important ingredients of a deprivation of liberty, and such importance can be seen from 33 years of Strasbourg jurisprudence from 1980 to 2009. and 13. And the wording is uniform throughout that 33 years, starting with Ghazadi. And if I could just give my lords and ladies the page references to plot through the chronology in due course. Ghazadi is in the bundle at 4188. The paragraph is paragraph 95. HL and United Kingdom in the bundle at 4626, paragraph 91. Stork in Germany in the bundle 4660, paragraph 73. Hedzia in Poland 4843, paragraph 57. Stanov in Bulgaria 4911, paragraph 128. And finally, Mihalos and Latvia 5000, paragraph 132. So that's very clear that there was a rational basis for concluding that that was an important set of criteria to utilise. And then when one looks at Stork, that of course must be looked at and read alongside the fundamental ingredient that a person must be confined to a certain limited place for a non-negligible length of time. And that's in Stork in Germany, paragraph 74 in the bundle at 4660. And there has been concern this week that the approach in Cheshire West regarding the acid test was reductive. It was a step away from Ghazadi, notwithstanding that it brought some certainty. And I'd like to address this head on. The Ghazadi list, or basket, I think my Lord Sales said, it's not a prescriptive, regimented list that one has to apply. They are matters that can be taken into account if relevant. And the specific words used by the European Court in Ghazadi were matters such as, prior to then listing, type, duration, effect, and manner of implementation. And what's really important is to bring this academic discussion back down to what happens on the ground. Because when assessments are being undertaken on a daily basis by health and care professionals up and down the country to determine whether somebody falls within Article 5, the Ghazadi list has not been forgotten, it's not been made redundant by the acid test, but rather the acid test provides the gateway or the threshold regarding Lim A. But other factors, including a Ghazadi-type list of concrete information, is still considered by those assessing. And it's very difficult to deal with this in the abstract, but if we go back to Arthur in his Perspex box and look at what would happen applying a Ghazadi approach in his situation, they're not difficult types of matters that Ghazadi deals with. These are bread and butter type of social care work analyses. So looking at the type of restrictions, well, of course, an analysis is going to look at the person's place of residence. So for Arthur, he's in the adapted bungalow in the domestic setting, and that would plainly be considered by the assessor, who would be ordinarily dealing with the assessment in situ, in Arthur's home. The duration, well, it's clearly not for a negligible period of time because this is a specially adapted bungalow for his long-term care. And the effect, the person assessing would be seeing that it was a care plan, it was being provided in his best interest, but that he was restricted. And the manner of implementation is that Arthur is in his Perspex box, he's being fed through a hatch, and you'd be looking at the concrete situation on the ground in terms of the level of care. Is it 2-to-1? Is it 3-to-1? Is Arthur able to go out? The level of physical restraint, chemical restraint, CCTV, whether there's removal of certain items in the property. So all of the Ghazadi elements aren't taken away. They are there in the background, but what Cheshire West was doing is bringing a focal point to allow certainty that was needed in these types of cases. So the summary position is that the acid test on the ground has not meant that a holistic appraisal of the individualised circumstances is not being considered. can I deal with the issue of compliance and lack of objection? We say that Cheshire West was not wrong in not taking that into account, and we say that that's consistent with what was said 20 years ago in HL and the United Kingdom, and the reference is in the bundle at 4626, paragraph 90, and this has been raised by different advocates, but it's the point that it's not a distinction of central importance whether somebody is compliant and has not attempted or expressed a wish to leave. So what was said in Cheshire West is consistent with HL. The reason or the purpose of a particular placement, I think that was raised by my learned friend, Miss Clement. The simple point is Cheshire West was not wrong in considering that was not relevant because that was consistent with two Grand Chamber decisions. The first being Austin and the United Kingdom, and that's at 4962, paragraph 58. And similarly, in the Grand Chamber decision of Krianga and Romania, at paragraph 93, 5056.
Which was the page number for Austin again?
The page number for Austin is 4962, my lady. The issue of coercion, that's been raised by the Secretary of State. The simple position that we raise, having dealt with this on a day-to-day basis, is that if P is subject to continuous supervision and control, then that may incorporate a coercive element. So, for example, if a person has to live at a particular place for a particular time and is being made to do so by another person and they don't want to, then there may be an element of coercion. So it's not a matter that's inconsistent. And the matter of Roman and Belgium, I would ask that you don't consider that in any great detail. This was the issue of measures depriving persons of their liberty, inevitably involving an element of suffering and humiliation. Well, the case is some 266 pages. I think that there's one paragraph or one sentence dealing with that, and no other cases specifically deal with it. And that's Article 3, and that's at page 5524, paragraph 142. And just to show a live example of how the court does consider all the circumstances post Cheshire West, and it didn't provide this reductive account. When one looks at Ferreira, Lady Justice, ardent as she then was, specifically says at paragraph 88, and it's 3215, whether the circumstances amount to a deprivation of liberty involves a question of assessing all the circumstances. So that's a clear example. And recently, the President of the Family Division and Court of Protection, Sir Andrew McFarlane, in the Jay and Bath case, said that Cheshire West naturally flows from the European Court of Human Rights judgment in HL and UK, and the reference for that is 3938, paragraph 49. If I could just deal very briefly with the case that you were taken to yesterday by my learned friend for the Secretary of State, RE-AB, and that's in the bundle at 3426. It was put to you that Cheshire West has created an absurd result, and that can be seen from this first instance decision of Sir Mark Headley. Well, we say if you read the judgment clearly says that this is a borderline case, and paragraph 11 on page 3430 specifically says that the court recognised that a judicial decision was needed on the specific facts of the case. So we say that doesn't take the Secretary of State anywhere. If I could deal very briefly with issue 4, my learned friend, Miss Butler-Cole, has dealt with whether the other regimes, so the Care Act, provides the protection if P is not deprived of their liberty. The one point I would seek to emphasise is that the Care Act isn't some sort of panacea that creates all persons to come under its umbrella. And if I could specifically give you 5 exemptions, it does not include those who are in receipt of NHS continuing healthcare. Secondly, it does not deal with those aged 16 and 17. It does not deal with people in Wales, where the Care Act does not apply.
What's the third one?
The third one is people in Wales, because the Care Act is not applicable. There are similar provisions in the Social Services and Wellbeing Wales Act of 2014.
Well, I mean, if there are parallel proceedings, it's not a very big point, is it?
They're not exactly the same words, but there is a point that there is a similar provision. If I can move on to a better point, self-funders, my lord. Self-funders is an important exception.
Yes.
And the self-funder would not fall within the regime where they have an annual assessment. And also those who fail the actual or fall below the national eligibility criteria. So the point being, my lords and ladies, is that there are a number of different care regimes in the community that are subject to different commissioning decisions and different funding issues that would not fall within the Care Act that you're being asked to look at as the panacea. And I would just ask you in due course to look at the supplemental bundle at page 1417, and it's the parliamentary Under-Secretary for Health dealing with the Mental Capacity Amendment Bill. It was debated in the House of Lords on the 21st of November 2018, and Lord O'Shaughnessy went through some of the exclusions and said, we would obviously not wish to be in the position of excluding the vulnerable people from Article 5 safeguards, so the specific people that would just not fall within the framework that the Secretary of State is inviting you to consider, and that's extremely important. You were referred to A Gloriously Ordinary Life by Miss Butler-Cole. That's the spotlight on adult social care. I would ask that you look, in addition to the page that she took you to, if you could look in due course at page 7511 to 7513. And it's the paragraph that starts at 220 and it runs through to 228. And it provides a whole host of real concerns that this is a broken system. And the point that the official solicitor wishes to make is that the government has not provided you with any evidence which casts doubt on the plethora of concerns raised by this Adult Social Care Committee report to satisfy, my lords and ladies, that the Care Act is this appropriate regime to use outside an assessment process involving the Mental Capacity Act. Finally, with 2 minutes to go, the issue of departing from Cheshire West under the 1966 practice direction. You've heard a number of points from my learned friend, Miss Kelly, which I will obviously not repeat. But the important point that I would like you to consider that hasn't been dealt with, and it's important but probably crucial, in the very unusual circumstances in which these issues are being considered, this court will need to consider whether any proposed change in the law is so complex or carries with it injustices or wider implications such that the matter is more appropriately left to the legislator. And I get that from Ex parte Hudson, and it's paragraph 26. And I will get the page reference for my lords and ladies, but the situation that you're being faced with, it would cause huge uncertainty. You would have all the thousands of people who are subject to a standard authorisation or a court authorisation needing to be reviewed. You have all of the cases in front of the Court of Protection, what happens to those particular persons and the uncertainty. But more importantly, on the 18th of October, so Saturday, we now know that there is a prospect of legislative reform in the near future with a consultation process, we are told, that starts in the new year. And the publicly available information says that that consultation will look at the issues that Ms. Clement was raising with you yesterday. So it's going to, we are told, address deep-rooted issues within the system by reducing the need for intrusive processes, providing better support for families, carers and health professionals. And the publicly available information is that the implementation of these safeguards will streamline the process. So all the concerns you heard about the multiple assessments that are distressing is going to be looked at and we're told there will also be a reduction in the backlog of applications, and they will be focusing on the most vulnerable. In this consultation, and this is important, they will seek the views of families, carers, practitioners, including social workers, nurses, psychologists, occupational therapists, and it's going to be run jointly by the Department of Health and Social Care and the Ministry of Justice. So in these very unusual circumstances, we would invite the court to exercise extreme caution and allow the government to take the steps that it now wishes to take, having properly consulted on the issues, as opposed to dealing with it in the manner that you're asked to, due to the wider inevitable implications that it will cause. I've 1 minute over. My lady, in relation to the LPS safeguards, would it be appropriate if I can just send the page reference in relation to where that is in the bundle? I don't want to trouble and trespass on my learned friend's time.
Thank you.
Thank you. Well, unless I can assist you further, those are my submissions.
Thank you, Ms. Sutton. Mr. McLean, one matter we are keen to hear from you on is how your submissions are affected by what was said in M against Ukraine and Stankov against Bulgaria, yes, about the need for consent to be assessed in a particular way.
Yes, I was going to deal with that squarely, Lord, yes. In the course of this reply, and with a focus on the reference, I want to address 4 topics at the level of principle. First is the autonomous concept, the ECHR concept of consent, and how that maps to the concept of capacity in domestic law. Secondly, the scope of Lim A and Lim B and how they interact with one another. Thirdly, I want to look at the issue of over-inclusion and the place of the voice of the patient. And then finally, I want to say something
about... Place of what?
The voice of the patient.
Place for the voice of the patient.
Yes. Oh, the voice of the patient. Sorry, continue.
And finally, I want to address briefly the Lim A issue, which is not squarely on our reference, but I don't want to avoid that point. And finally, I'll say something about safeguards. And I will turn to the authorities my Lord has raised with me. Firstly, it's clearly accepted across the court that the effect of Section 306 of the Mental Capacity Act in Northern Ireland and the English equivalent is that the court has to carefully track the Strasbourg jurisprudence in Article 5. The key source of that is the Grand Chamber decision in Stanev, which we must turn to as a touchstone in this area. We say 3 points are clear from Stanev. Firstly, the Gazardi concrete situation has to be taken into account in every case involving the assessment of deprivation of liberty. That's paragraph 115. We'll come back to that. Secondly, the acid test identified by the court in Cheshire West is a subset of those Gazardi factors, and the court will look to see what's not embraced by the acid test. And thirdly, from Stanev, there is an additional subjective element that has a function over and above the Gazardi test and necessarily the acid test. And if one keeps those points in mind and reflecting on the submissions that have been made, we say some of the points become clearer in terms of understanding. So firstly then, the autonomous Strasbourg concept and approach to consent. The source of the Stanev paragraphs 115 and 117, which you can find at page 4909 of the
Sorry,
case.
I missed the reference. Could you?
4909.
Thank you.
This is Stanev. Paragraph 115, I'm sorry, begins in 4908, running into 4909. Paragraph 115 is a restatement of the Gazardi test, and you'll see that in the last sentence. It refers to the range of criteria to be taken into account: type, duration, effects, manner of implementation of the measure in question. One notes, for example, concepts of effects are part and parcel of that part of the Gazardi test. there may well be subjective elements involved in any consideration of the effects of the concrete situation in that regard. The source in the footnote 56 is Guzzardi and back to Stork, and I'll take the court to Stork in a moment to make good a point in respect of that. Paragraph 117 deals with the subjective element, and again you will see this is to be traced back to the Stork decision at 58. So paragraph 74 of Stork is affirmed by the Grand Chamber in Stanev. And then if one turns to Stork, which is found beginning at page 4644, the operative part of the judgment is at 4659 and 4660. You'll see this is where the two aspects, the objective and the subjective element, are first introduced. The facts of the case are of some assistance in this regard when one comes to consider the autonomous concept. You will see in this case, paragraph 75, that the applicant in question was considered to have capacity. So she had capacity to make decisions. You see that in the middle of paragraph 75. But paragraph 76, what the court does then is it analyses the case in two ways, both on the presumption that she has capacity and the presumption that she does not. And in this case, you'll see that the court first looks at the consideration at the top of page 4661. So the court's unable to discern any factual base for the assumption the applicant, presuming her capacity consent, had agreed to her continued stay in the clinic. It then goes on in the alternative, and it's the alternative aspect which is of interest here. In the alternative, assuming the applicant had no longer been capable of consenting following her treatment with strong medication, she could in any event not be considered as having validly agreed to her stay in the clinic. So here you see the court looking at a scenario where there is no capacity, and yet going on to consider whether or not, in this case it didn't matter because there wasn't anything to go on, whether or not there was agreement in the circumstances. And this is an indicator, we say, that the concept of consent that's being addressed by the Strasbourg court is something different from MCA type capacity. It's something beyond that. And what you'll see here, we say, in Stork, is a foreshadowing of what later happens in Mihailov's. This is a hypothetical example of that. Mihailov's case is an actual example of that, so a concrete circumstance. We say this is the foundation of a line of authority which takes you through into the Shuktakurov case. I've shown you that. Don't need to turn any of these up. I'll give you the references. We've looked at all of them already. Paragraph 108, page 4875. DD, paragraph 150 at page 4792. Kedzior, paragraph 58, that's page 4846. And then Mihailov's, again, which we've already looked at in detail. So Mihailov's is not a single case outlier, a one-off. What it is the outworking of a line of reasoning which can be traced back to Stork. Stork is then affirmed in Stanev by the Grand Chamber, and you see its application in a sequence of cases consistently applied by the Strasbourg court. And that's the basis for our submission that the autonomous concept used by the Strasbourg court is qualitatively different from MCA type capacity. And that.
I mean, I can see in Mihailov and some of the other cases that can be said. But if you go back to Stork at 76, when they discuss the alternative, what they say is, assuming the applicant had no longer been capable of consenting following her treatment, she could, in any event, not be considered to have validly agreed. So is it really setting up the line that follows?
Well, it's setting up the structure for it, Lord. I don't lay too much weight on that, but what you'll see is the consistent application of that in the cases that follow, and that leads into Mihalov's. So we say the line of reasoning begins there, but I don't overstate the point nor for that reason. Can I then, I'll come back to M in Ukraine and Stankov presently. Can I then turn to the, while we're dealing with these authorities and the having open, or we may still have open, the decision in Stork, the relationship between Lim A and Lim B and its treatment in Cheshire West. So it's our submission that Lim A and Lim B do not sit in hermetically sealed silos, that there are aspects of the subjectivity analysis which can find a home in the concrete situation analysis. And for example, I've alluded to the effects dimension of the Ghazardi test. The text of the Lim B approach, the actual text as set out in 117 of Stanev, if you have that again, which is at 4909. Picking it up in the last sentence, a person can only be considered to have been deprived of his liberty if, as an additional subjective element, he is not validly consented to the confinement in question. So how that's described is important. The reference to an additional subjective element indicates that this doesn't capture the totality of the subjective elements. There's something else going on. Where is that something else going on? Well, it may well be in a Ghazardi type analysis in Lim A. But why has the court separated Lim B out in this way? In our submission, it's because it's a factor that's intended to have an additional and potent effect. And again, you'll note the use of the words can only. A person can only be considered to have been deprived of his liberty if, as an additional subjective element, he's not validly consented to the confinement in question. The flip side, or the obverse, has to be true. If there is valid consent to confinement, then it cannot be a deprivation. We say the additionality is very important here. The impact or consequence is important. And this element of the Stanev test cannot be ignored by the domestic court. And that, of course, is the issue that arises from Cheshire West. We say the point is thrown into very sharp focus by Cheshire West itself. We can go back to that. I know we've looked at it several times, but if you have Cheshire West, and find it. Beginning 2927, I'm going to ask the court to turn to paragraph 37.
Page?
That is at 2948.
Thank you.
So, this describes the second question. What's the essential character of a deprivation of liberty? Its common ground, three components can be derived from Stork, paragraph 74-89, confirmed in Stanev, which is the passage we've just been looking at. The objective component of confinement in a particular restricted place for not negligible length of time. B, the subjective component of a lack of valid consent. And C, the attribution of responsibility to the state. Now, this part of the judgment doesn't explain why Lim B, Part B, is not an issue. We know from the Court of Appeal judgment, it's been discussed already today, that it was clear that the two girls, Meg and Meg, did not have MCA capacity. But if we look at paragraph 55, which is on page 2953, it seems clear that the judgment here is not confining itself to MCA type capacity. And in our submission, that becomes clear from letter D onwards. If the tacit acceptance of the applicant was relevant in Mihailov's, Why should the same tacit acceptance of Mig and Meg not be relevant too? That's noted to be the most difficult aspect of the case. Mihailov's was different because it had a level of de facto understanding which enabled him to express his objections to the first placement. That's, we say, important. Then, this same paragraph notes the Strasbourg court's approach. So the Strasbourg court accepts that there are some people who are not capable of expressing view either way, and this is probably the case with both Mig and Meg. So we say this paragraph shows that Mihailov's is distinguished not on a standard MCA capacity type basis, but because he had an element or a level of understanding. Secondly, the paragraph identifies a separate approach of the Strasbourg court, which is assessing autonomous consent in legally incapacitous patients.
But I'm so sorry to interrupt. Isn't 55 all about the objective limb? It's not addressing the subjective consent limb.
Agreement, because the subjective limb has been discounted in one sense, but why then are we asking questions about what Mig and Meg can probably or possibly do? So we say the subjective dimension is coming back into the judgment in paragraph 55.
In terms of the effects, or you're saying in terms of consent? In
terms of consent, views, wishes, feelings, expressions. So it's factoring back into the analysis. So we say this is an indicator that even in this judgment, there was a recognition that there was a separate Strasbourg concept in play. That's what gives rise to the Mihailov's decision. That's what's under consideration here. And
what is your submission about what the outcome should have been in relation to Mig and Meg?
Well, we say, Lord, the analysis here is too austere. If one goes back to paragraph 134 of the first instance judgment, which is quoted later in Lord Clark's analysis, we say the outcome ought to have been a recognition of their subjective expression of wish, applying the Strasbourg approach.
What do you say should have been the outcome in P?
P, we don't contend for any different outcome in P. But Mig is the test analysis here.
So what do you say is the test for consent as the autonomous concept in Strasbourg case law?
We say it's as identified in Stanoyev and Mihailov's. One looks to see beyond the question of capacity whether or not there is an expression of view, wish or feeling, wishes or preference by the individual. That's what one's looking for.
And you're going to get on to M and Ukraine.
Yes, I will do, yes. This approach, which the majority adopt, we say can be tied back to the arguments presented by the charities, both yesterday and in 2013. You see, if you go back to page 2951, the acid test dimension is set out at paragraph 49, continuous supervision control not being free to leave. And then at paragraph 50, Lady Hale adopts with approval the position of the charities. And you'll see just below letter G their contention that the person's compliance or lack of objection is not relevant. And that's because once you get to MCA incapacity, you don't take the matter any further. That aligns with the submission that was made yesterday. What is wrong with that? We say it gives rise to the problem which was acknowledged candidly both yesterday and today by the charities, the problem of over-inclusion. There necessarily will be individuals subject to deprivation of liberty safeguards who simply not ought to be involved in that framework at all. It suggests that that's a necessary evil and for the noble purpose of obtaining the benefits of safeguards more generally on a utilitarian calculation, that's what should happen. So that rationale and reasoning, we say, was adopted by the majority in Cheshire West. We know, however, from the statistic we've seen, that the over-inclusion issue is not trivial. We know, and it's in the Secretary of State's case, that there are 5 times more individuals detained under this regime than there are in the prison population. So the extent of the over-inclusion, we cannot put our finger on it.
It's difficult to know how many are over-included, isn't it?
It's not tens, we'd venture hundreds. It's clearly significant. And the contention based on the proposal the Northern Ireland Minister put forward is that we have a more closely calibrated regime that seeks to reduce the obvious problem of over-inclusion. Second difficulty with this approach is that it is a blanket approach that applies in all cases. If we equate MCA capacity with the convention approach, and the blanket approach is again considered to be problematic in this context. You have some evidence on that point, for example, from MENCAP, one of the charities involved yesterday. There's a witness statement. I don't need to open it, but at paragraph 177, page 177. We do not believe the wishes and feelings of people who lack capacity to make decisions about the arrangements for their care and support can be used to establish ongoing consent in relation to confinement. That's a blanket position, which we say actually abrades with the principles which underpin the Mental Capacity Act in England and Wales, sections 1 to 4 of the 2005 Act. Look to those again. It also abrades with the principles that underpin the Northern Ireland Mental Capacity Act. Again, it's a principles-based approach, see sections 1 to 6, and also the Scottish Adults with Incapacity Act. Each of those statutes, and particularly the English and Northern Irish Mental Capacity Acts, have an underlying philosophy of enhancing the autonomous decision-making, even of those who lack capacity. So there are sections there that allow for support. There are sections there, for example, that require consideration of wishes and feelings when the best interests calculations are being made. And we say that runs against the grain of the types of arguments that are presented against us here. There's a valuable submission made by the Scottish Mental Welfare Commission, which you'll find in the supplementary bundle. It's page 97. If you have that. And taking issue with this is at page 97, paragraph 3.34 of the Mental Welfare Commission for Scotland submission. They disagree with this approach adopted by the charities on the basis that it seems to suggest that some adults will find it difficult to communicate and express views about their placement. Therefore, the views of no adults should be capable of vouching consent. That, in their view, creates an arbitrary threshold which requires unnecessary and therefore disproportionate interference with the private lives of those incapable adults who are able to express those views and feelings. And he goes on to make the point, which I think we made in our own written case, is that this approach, the over-inclusive blanket approach is contended for here, has to be read in light of the Article 8 rights that are also in play. So if we engage all the machinery of the state and the safeguarding processes that are involved.
Is there any Strasbourg case which has seen Article 5 rights as needing to be balanced against Article 8 rights?
I'm not sure I can identify one really, but at the level of principle, it seems to us that in this territory there is a need to have regard to that balance.
Mr. McLean, could I just take you back to paragraph 50 of Cheshire West at page 2951, yes. And the persons at the bottom of that paragraph, Lady Hale rules out the purpose of the person's compliance or lack of objection is not relevant. As I understand you say that compliance and lack of objection is relevant to tacit agreement. Is that right?
It is, yes.
But it's apart from that not relevant. Is that right?
It's the subjective element has to be engaged in every case. It's relevant there, and that's at home for it. If on the counter-analysis that one only looks at limb A, and there's nothing else in play, and this is kind of the department's case, I think, on this point, we say there may be scope for these sorts of issues to be looked at in subjective causality, but we say the proper place for this analysis is in limb B because of the enhanced potent aspect of that additional safeguard.
Also, Lady Hale rules out the reason or purpose behind a particular placement is not relevant. And what do you say about that?
Again, we say those are proper causality factors that are relevant.
And what authority is there for that?
Given the judgments in Austin and Krianga, can one advance that argument?
No, I'm sorry, we're not advancing that case.
No, I thought you said yesterday you accepted that purpose was not.
I'm sorry, I've been corrected by my learned junior on that point.
And coercion. What's your position about that?
Well, I think we took the court to Firat in Turkey, and the fairly clear indications there. There's FOCA in Turkey as well, which both make the point that coercion is a proper ingredient of the Article 5 analysis.
Thank you. Thank you.
Back to my Lady Rhodes' question about a Strasbourg authority balancing Article 5 and Article 8. I'm grateful to my learned friend Mr. Rockeen, who tells me that TW and Enfield is not a Strasbourg authority, but it's an English Court of Appeal decision of 2014.
Sorry, can you give the name again?
TW versus Enfield, and I'll have that reference at 2969. I'm being assisted on my feet with that. I'm assuming it's correct that in there balances Article 5 and Article 8 in this context. So, the over-inclusion problem, we agree, as all parties appear to agree, that there is an over-inclusion issue here that involves necessarily potential interference with Article 8 rights and also can result in the voice of the incapacitated patient not being heard.
Well, it's heard at a different stage, isn't it? It's heard at...
Can be, really, that's the point. It is heard at a different stage, for example, in the Mental Capacity Act if you engage Section 4.6 best interest test. So wishes and feelings do feed in at that juncture, and these are given effect. We say there's, again, nothing heretical about our code, our proposed code, introducing those at the subjective. What Strasbourg says is the critically required additional safeguarding stage. So that's where those belong. I showed you on Monday, we don't need to open it again, but the schedule to the English Mental Capacity Act, page 740, which again, this is outside the best interest analysis, separate part of the Act, the schedule of the Act. You'll see the wishes and feelings of an incapacitated patient, somebody who doesn't have capacity, being used as a mechanism to determine whether they adopt or move into one regime or another, Mental Health Act or DAWLS. So Parliament has already deployed this concept with the...
Remind me the page number?
740, my Lord.
740, thank you.
And that's quite important, we say, because that shows in domestic law consideration being given outside capacity, so with an incapacitated patient, to the expressions of wishes and feelings be used on a topic that is legally dispositive, so it will make a fundamental difference to their case. And these are persons without capacity. So that's, we say, very illustrative of our system, recognising a difference between the Strasbourg autonomous concept and MCA Section 2 incapacity. They are different, not just in Strasbourg, but also in our domestic law. And it's in that area, so outside capacity, where wishes and feelings are taken on board, we say that paragraph 117 Stan Ev applies. That's where the additional protection sits. As Lady Rose indicates, our courts do give serious and sometimes dispositive consideration to the wishes and feelings of patients without capacity. In this context, two examples. The decision of the Supreme Court in Aintree and James. You'll find that at page 908. The relevant paragraph in Lady Hale's judgment is paragraph 45 at page 2925.
Article 8 was raised a moment ago, but there is in the bundle quite a lot about Article 8. And it's, I think the case we have that discusses it particularly is the Shtukaturov and Russia case. It's particularly pages 4871 and following. And the problem there was that under Russian law, if you lacked capacity, if you were assessed as lacking full legal capacity, then no regard was paid to your wishes, and that was held to be a breach of Article 8 in paragraph 95.
Yes, I'm grateful, my Lord. I think we had opened that authority earlier but not spotted the point, but yet it aligns with my principled analysis of this, that there must be a balancing required of Article 8 rights in Article 5 in this context.
Yes, I mean, what they say is that, essentially having set out what the European principles were, they say, contrary to these principles, Russian legislation did not provide for a tailor-made response. As a result, the applicant's rights under Article 8 were limited more than strictly necessary.
Yeah. Well, that ties with my submissions in respect of the blanket nature of the approach. If we say there's nothing beyond capacity, if we stop at Section 2.1 Mental Capacity Act and go no further, then we say that leads one into that territory necessarily. And that's the difficulty with the submission made on behalf of the charities. I was referring the court to Supreme Court decision Aintree and James, a case involving a patient who was minimally conscious, end-of-life case, and it's an illustration of the Section 4, subsection 6 provision in the Mental Capacity Act being brought into play and weight being given to the wishes and feelings of a patient who's clearly in extremis. Paragraph 45, Lady Hale noting that the purpose of the best interest test, consider the matters from the patient's point of view. That's not to say his wishes must prevail any more than a fully capable patient will prevail. But insofar as it's possible to ascertain the wishes and feelings, his beliefs and values are the things which are important to him, it is those which should be taken into account because they are a component in making the choices that are right for him as an individual human being. And again, we say that sentiment flows from the Act, read as a whole, and we say the proposed revisions to the Code again align with that. For a more up-to-date illustration of the same kind of concept being played into the analysis, I'll refer you to a decision of the Court of Protection in the supplementary bundle, page 497, in W.A. and Avon Wiltshire Trust. Refer the Court to paragraphs 45 to 51 and paragraph 93. This is a case involving someone who was refusing all food, was in a perilous state, and the court was considering whether a treatment option involving non-consensual feeding was appropriate.
So I got the page wrong there.
497, I hope, Lord.
497.
And what were the paragraph references?
45 to 51, my lady. That's page 514. And then the conclusions are at 93 and 102. Again, recognising this is a different part of the analysis, but again showing very starkly the court giving effect to the wishes and feelings of someone in a state of incapacity. We say again that reflects the broad philosophy of autonomy enhancing, which is threaded through the legislation. Can I go? So. paragraph 93 of that, which I have at 537.
Page?
537, supplementary, my Lord. Yeah. I won't read it, but the court can look to that. And then at 102, the court concludes that the treatment option, the plan, is not considered to be in his best interests. At the bottom of that paragraph, no effort should be spared in encouraging him to choose life. That said, I've come to the clear view that when he says no, his refusal to be respected. No must mean no. That's an incapacitated patient expressing wishes and feelings taken into account by the court in that context. Can I go back to M in Ukraine and Stankov, the authorities that our Lord President asked me to look to? M in Ukraine begins at 4810. And the reliance placed on this case is obviously important, because this is the contention of the charities that, in fact, there is no gap in Strasbourg between their autonomous consideration of consent and our general domestic law understanding of capacity and capacity. The two are aligned. That's the contention. And what we say about this decision is, first of all, it relates to an admission to a psychiatric hospital for treatment in the...
Yes, but we know in Stankov that's extended to admission to care homes.
Exactly. But starting with the analysis here, we say, I of course accept that, my Lord. Focus in this case is on admission for the psychiatric treatment, and you'll see this at 76. That's page 4833. And this is a reference to certain international standards. So you'll see the international community has developed a set of relevant principles under which the validity of a patient's consent to psychiatric treatment can be ensured. In particular, under Principle 11, subsection 2 of the UN principles, an agreement to psychiatric treatment implies a patient has been provided with, these are various procedural formalities, adequate and understandable information, the formal language he understands, the purpose, method, likely duration, expected benefit of the proposed treatment, alternative modes, side effects, and so forth. And you'll see the text of that is back in the body of the judgment at page 4820. So these are the UN principles for the protection of persons with mental illness, the improvement of mental health care, approved in 1991. Principle 11, consent to treatment, is directed, you'll see 11.2 is the one which the court's just been pointing to, indicates what must be provided in terms of the information for a diagnostic assessment. You'll see that under 2A, B, C and D. Going back...
Do you know what paragraphs 6, 7, 8, 13 and 15 say? Or are they not relevant?
I don't think they're
not
relevant for our purposes. But going back then to page 4833, you see now this paragraph 76 is pointing back to that very defined process under the UN principles. And then paragraph 77, and it says accordingly, so having regard to that and the CPT, which is also referred to above, the court takes the view that a person's consent to admission to a mental health facility for inpatient treatment regarded as valid for the purpose of the convention only where there's sufficient evidence suggesting the mental ability to consent to comprehend has been objectively established in the course of a fair and proper procedure, that all the necessary information concerning placement and intended treatment has been adequately provided to him. what we say about that is, analysed properly, that's a process requirement. So that's about ensuring certain procedural steps are taken, evidenced, and objectively verified. It's driven at a fair and proper procedure. And you'll see that's clear from the next paragraph, which deprecates the quality of evidence that's provided in that case. So you'll see paragraph 78, the complaint is the only document evidencing her consent is her admission application. The domestic law required more, no countersigning had been provided, no evidence suggesting her mental inability consent was established, the consequences were explained, and so on and so forth. So we say what this goes to is not the substantive Section 2.1 MCA analysis, whether someone can take the information in, believe it, retain it, use it. It goes to the question of whether there's been a procedure properly followed. It's a process-driven point. And we say that, in this case, doesn't equate to MCA capacity, and it doesn't undercut our general point or the STANEV line of authority that there is something different, a Strasbourg concept, an autonomous concept of consent.
And will you take us to, I mean, if such a process is necessary, is such a process provided for under this proposed scheme?
In our code, yes. That's the last point I was going to come to, Lord, in respect of that.
Well, it would also need an amendment to your, if it's a process, to the referred question at page 4, paragraph 1. Because at present, you don't separate out those admitted to a mental health facility for inpatient treatment.
No, we don't. That's again a feature, right. But that's a feature of the Northern Ireland. We shouldn't forget that the 2016 Act in Northern Ireland is different from the legislation in England because we have the fused system of, or we're intending to have a fused system of mental health order care and mental capacity. So our statute's different.
Insofar as a person in Northern Ireland is detained in a psychiatric hospital, mental health facility for inpatient treatment, the consent wouldn't be through expressions of wishes and feelings. It would have to be consent in accordance with proper information about the treatment he was receiving.
Yes.
Yeah. So therefore, your question would have to be amended.
Maybe right, Lord.
Yes.
I'm not disagreeing with that.
So wait a minute, you're saying there's a different test for consent depending on whether they're going to be an inpatient in a psychiatric hospital? Would you just assume that nobody would wish or feel that they wanted to go into that place? Or I don't quite understand the point that's now...
I thought you were saying that this is a process requirement.
Yes, that is
and therefore, so provided that the code contains a process that will enable objective establishment of the person's consent in a fair and proper procedure. The question is the same.
The question is the same, exactly. And
yes, maybe the answer has to be conditional.
The answer has to be, and also, again, back to where we were at the beginning, this is a draft code which we're testing its potential legality. The safeguards and supplements are work in progress. But my point, I suppose, in terms of I know why Lord President's asked me to look at this case. It's to see whether or not it is a fundamental problem in the analysis. And we say, no, it's not. It's not a fundamental problem because it doesn't go to that issue. It goes to procedure in terms of consent. So the idea of the...
It goes to the procedure for ascertaining whether the wishes and feelings that someone is saying this P has, P genuinely does have those.
Yes, that's exactly.
Subject to all the problems that the charities have made about, well, wishings and feelings about what, but that's a qualitatively different test from whether they understand the nature of the restrictions that they're under, or that there's, so that's your case. But I didn't understand you to be saying that that's limited to social care, as it's been called.
Well,
it may in practice be, but the nature of it may in practice be more difficult to satisfy that if you're admitting someone to a psychiatric ward, but does the nature of the consent test turn on where the person is going to be detained?
It shouldn't necessarily, no. I mean, we shouldn't lose sight of why we're dealing with this. We're dealing with this because the case the charities make is we're all wrong about the autonomous Strasbourg concept. It doesn't exist. It's really exactly the same as Section 2.1 MCA. There's no space for any.
No, I know that's what we understand. I think we all understand that point. What we're trying to work out is when do you say that that test applies?
It has to apply across the board. We can have different tests.
At the moment, I can't. The autonomous concept for which you're advocating is a person with sufficient understanding, as opposed to legal capacity. Yes. Understanding what? Here they are. They're actually specifying what they have to understand, and because it's sufficient comprehension, sufficient understanding, not legal capacity, but. I have difficulty with the concept that this is just a process. It is actually setting out what the understanding has to be about.
Yes, in that particular context.
In that context.
I accept that, but we're looking at the different concept of generally social care detention, and what people need to be able to express a view about is whether or not they assent or not to the confinement, which is a different issue, we say. So this is not.
I can see the argument that this is a different area, and that is valid consent for a psychiatric patient may have to be different for inpatient treatment in a psychiatric in a mental health facility, may be different from valid consent in a home environment. But at the moment I have difficulties about this just being process as opposed to informing you as to what the consent has got to be.
I'm not sure I can take the point any further more than that. The next issue that's raised, of course, is that Lord President's identified that M in Ukraine is translated into the social care context in Stankov, I think. Stankov in Bulgaria, 5131. So translated judgment. It's not entirely clear at times what's being said. But again, we recognise page 5207. There's a read across of the M and Ukraine analysis.
This time the express word, instead of ability to consent, capacity to consent.
Yes.
That if it's a translation, it'd make nothing.
Exactly. There are problems with the translation. There are parts of the case which don't seem to translate the Stanev tests accurately either. If you go, for example, to page 5204, paragraph 84.
There is an English translation on the HUDOC website.
Is it? Well, this may be the one that we're looking at. I don't know, but
that's an official translation.
Sorry, I'm now a bit confused. So are you saying that
the wrong case?
What we're looking at is an unofficial translation?
Am I looking at the right case?
My Lord, it's reobtained the translation. The Stankov that my Lord found on the Strasbourg website is a different Stankov case. It's not this case.
Oh, I beg your pardon.
It's only available the judgment in the Vandal is only available in French.
Oh.
The official translation.
Yes, you're quite right. I beg your pardon.
Officially translated by the court, by the Strasbourg court.
No, by a translator.
No, you're quite right. It's only available in French and Bulgarian.
Yes. Well, that explains my concern about the judgment. For example, page 5204, paragraph 84, as a sort of bellwether point, doesn't seem to accurately capture Stork paragraph 74. Because, as we know, key point, Stork paragraph 74 is an essential additional or an additional requirement. This is talking about, and this is a subjective aspect. So Where does that take us? Note of caution about the paragraph 90 provision. Lord Jones has noticed the capacity concept being used there. But it still goes back to my primary point about M in Ukraine, which is the nature of the analysis there was directed to something different than the autonomous concept of capacity.
In paragraph 89, I'm now nervous citing this because...
yes.
But the court refers to, in the middle of that paragraph, the fact the person is deprived of legal capacity does not necessarily mean that he or she is incapable of understanding his or her situation. So, I mean, is that the court indicating that that's the sort of relevant level of mental facility that one needs in order to express consent?
If it is, it sits uneasily with paragraph 90 and the section we're looking at.
But it is consistent with Shtukarova and Stanev and those paragraphs that are cited.
Yes.
89 is dealing with his refusal to consent, as opposed to 90 being his actual consent. If I read it correctly.
Well, our overall submission in respect of these cases, I think the court probably has, is that it doesn't negate the existence of the space the Strasbourg Court have identified beyond capacity for individuals to express their wishes and feelings.
So the I'm not going to pronounce it properly, but the case beginning CH actually is our SH.
Yeah.
Yes.
Well,
sorry, I
assume that's right.
Picked that up.
Yes.
Yes, paragraph 108 indicates it's the same paragraph.
It is.
Right.
And Stanev at 130 as well.
Yeah. Given the boilerplate drafting technique, we can probably, if we do a comparison, we can work out what an official translation might look like.
Yeah. That's probably as much as I can assist the court with on that point. The Lim A point, which Lord Stevens asked me about this on the first day, what our position was in respect of the practice statement on Lim A, and I wasn't avoiding the question, but I said it didn't arise on our reference. It's not in play on our reference. The logic of our argument, again, of course, is that the court has to trace through the Strasbourg jurisprudence into an examination of whether Cheshire West properly reflects all of that. And we say the court doesn't need to go there for the purpose of our reference, but it appears to be fairly clear that the acid test is a subset of Ghazardi factors. It is not a clear transposition of the Ghazardi factors into that case. We have some concerns about the Secretary of State's submissions on this point. Their contention is everything is done in Lim A, including the subjective aspect of it. Our conceptual difficulty with that is what work is being done by Stanev, paragraph 117, the additional element, which is particularly potent and is critical for the analysis. So on the Secretary of State's case, we see some difficulty with that. We say the policy position the Minister has struck here is an appropriate corrective policy because it does give effect to 117 of Stanev. The Minister in Northern Ireland, no doubt, and the Attorney are also mindful of the risks of worsening a situation with additional legal uncertainty if we go that far, which is, again, why the policy position here raised only the para 117, not the Lim A test. So if the court confines itself to the reference, there is no issue. If the court doesn't confine itself to the reference, then our submission is there's a mismatch in Cheshire West, which we can identify. What the corrective is another matter, and we see problems with the proposal that's been advanced. A lot of time has been taken up in this reference on the Lim A point, and a lot of the submission has been made in respect of that. We say a sharp focus on the reference is an appropriate course here. Last point, probably at time now. The court did ask me about procedural safeguards. We have provided a 10-page note, which is on the portal, shared with all the parties, setting out procedural safeguards in Northern Ireland. They're a close approximation to the annex which the Secretary of State for Health provided for England and Wales. So if the code is one that can lawfully be made, there are safeguards already and more to come which can address these concerns. My Lords and Ladies, I've probably trespassed too long in your time. That's our submission.
Thank you very much, Ms McGlean. Well, we're grateful to all counsel for their assistance. We will have to take time now to consider your submissions. This isn't a straightforward matter, and it will take us some time. The court will adjourn.